You have just received a notice of hearing from the Colorado Office of Administrative Courts informing you of the date of an upcoming hearing. Undoubtedly, you have questions concerning what will occur at this hearing. We will try to answer many of those questions in this presentation. It is important to note that while the Office of Administrative Courts wants to help you navigate your hearing as much as possible, we are prevented by law from providing you with legal advice. The Office of Administrative Courts is the adjudicatory body that resolves disputes between the citizens of Colorado and state agencies. If you have received a notice of hearing, you have disagreed with the state agency's decision. It is the Office of Administrative Courts' job to provide a fair administrative hearing for all parties in reviewing the state agency's decision. The Office of Administrative Courts will use the applicable statutes, rules, and regulations to resolve your dispute. The Office of Administrative Courts has links to most of the laws that may be applicable to your case on its website under the Resources link. Over the next few minutes, we want to share with you what to expect at your hearing, including who can represent you, what the burden of proof is, what are opening statements, what is direct examination, what is cross-examination, what documents and evidence can you present, what are objections, what if I do not agree with the decision of the administrative law judge, as well as other frequently asked questions. But first, let us explain what an administrative hearing is. An administrative hearing is a trial before an administrative law judge. Such hearings can range from simple arguments to something that is similar to a full trial. In an administrative hearing, witnesses can testify, be cross-examined, and evidence can be introduced. While administrative hearings tend to be somewhat less formal than trials in a county or district court, the rules of evidence still apply. There is no jury during an administrative hearing. It is the administrative law judge that makes the initial agency ruling. This ruling, or order, is then sent to the state agency for a final ruling. The final decision of the administrative law judge or the agency at an administrative hearing can be appealed to another court. Your hearing will be very similar to a trial in court with witnesses, exhibits, and rules of evidence. You should arrive at the place where your hearing will be held before your scheduled hearing so that you and any witnesses may be seated in the hearing room. The hearing will be tape recorded or digitally recorded on a computer. The hearing will not be open to the public, but you may bring friends and relatives to your hearing if there is enough room. In general, the Office of Administrative Courts will hold hearings in public benefits cases in one of two manners, by telephone or in person in one of our courtrooms. The notice of hearing that you received from the Office of Administrative Courts will tell you which manner of hearing you are scheduled for, as well as the date, time, and location for the hearing. Most of the public benefits cases will be held by telephone. If your hearing is by telephone, you will be seated next to a speaker telephone, usually at the county department, and the judge will participate by telephone with you and the county worker. If your hearing is in person, also known as a face-to-face hearing, your hearing notice will usually have you appear at our offices at 1525 Sherman Street on the 4th floor in Denver, Colorado. The hearing notice again will provide you with the date and time of your hearing. You may be represented by an attorney, or you may appear on your own behalf. It is up to you to decide whether you will hire an attorney. The Office of Administrative Courts cannot appoint one for you. A list of free or low-cost legal services for indigent persons is available on the Office of Administrative Courts website. In addition, the Colorado Bar Association keeps a list of attorneys who you may be able to consult for no charge. The Office of Administrative Courts website has other links to free or low-cost legal services available to you. In some types of cases, a friend, relative, or non-attorney advisor may represent you. These individuals are called non-attorney representatives. However, if you decide to have a non-attorney representative, the requisite form must be filled out and signed by you. This form is available on our website for both Medicaid and non-Medicaid cases. Remember, If you represent yourself, you will be responsible for knowing the applicable laws to your case. Self-represented parties are held to the same standard as attorneys. The judges cannot legally or ethically help you with your case. In general, the burden of proof in public benefits cases is a preponderance of the evidence. The respective State Department rules adopt the Colorado Administrative Procedure Act, which assigns the burden of proof to the party who is the proponent of an order. For example, if you are not currently receiving benefits and your application was denied, you will be required to prove by a preponderance of the evidence that you are eligible to receive the benefit. If, however, you are receiving a benefit and the county has determined that it is going to terminate or alter that benefit, it is the county's burden to prove by a preponderance of the evidence that you are ineligible to receive the benefit. In general, only intentional program violation cases have a different standard of proof, which is clear and convincing evidence. When the hearing begins, each party may present an opening statement. An opening statement is a brief outline of the evidence that you expect to present. The opening statement is not evidence, and neither side is required to make one. Each side is allowed to call witnesses, who will take an oath to tell the truth. The party with the burden of proof calls the witnesses first. You may call witnesses to ask questions about the facts of your case, and you may testify yourself. A witness is questioned first by the party calling the witness. This is called direct examination. The opposing party may then question the witness. This is called cross-examination. On occasion, additional questioning by each side, otherwise known as redirect and recross-examination, may also be permitted by the judge. Let us discuss both direct and cross-examination a little more. If you have a witness, you can call them to the stand and ask the witness questions. Direct examination is simply an individual telling the judge what he or she knows about the facts of the case. Remember, during direct examination of a witness, you should be asking the witness questions and not simply testifying yourself. In addition to calling witnesses, you can testify on direct examination. If you testify, you are simply telling the judge what you believe he or she needs to know about your case. In some situations, the judge may also ask you or other witnesses questions in order to clarify the record. But remember, as stated before, the judge cannot help you present your case. Cross-examination is the opportunity to ask questions of the witness called by the opposing side. The cross-examiner will not be permitted to simply make statements. You must ask the witness a question during cross-examination. If you testify, you may be asked questions by the opposing side on cross-examination. Remember, both the witness and the cross-examiner should be controlled and professional. We understand that you may feel certain emotions during your hearing, but it is important that all parties display the proper courtroom decorum. There should be no arguing between a witness and a questioner. Both sides may offer documents or other materials as exhibits. These should be documents that are pertinent to the case that you have before the Office of Administrative Courts. Documents can include such items as letters, contracts, business records, or medical records that help prove your case. You may also bring photographs or other items that relate to your case that you want the judge to consider. In public benefits cases, you or your representative have the right to examine, at the county's office, all papers and records which are to be used at your hearing. The county may charge a nominal cost for copies of the documents. Call or write the county and ask to see a copy of your file and any other documents or relevant evidence the agency has regarding your case. It is important that you bring the original and at least 2 copies of any documents to the hearing, one for you, one for the judge, and one for the opposing side. Each side has the right to object to any of the exhibits that a party requests to be admitted into evidence. In addition, each side may object to any of the testimony offered by the other side. The Colorado Rules of Evidence control what is allowed at a hearing. If you believe that evidence or testimony is objectionable, politely tell the judge that you object and explain why. If the opposing side objects to your evidence or testimony, politely tell the judge why you believe that the evidence or testimony is relevant to your case. The judge will then decide whether or not to allow these exhibits or testimony into evidence. In a public benefits case, after the hearing, the judge will issue a written order called an initial agency decision. If you disagree with the decision, the final paragraph of the order will tell you how you may appeal to the Office of Appeals. For Medicaid benefits, you will send your request to the Office of Appeals, State Department of Healthcare Policy and Financing. For all other public benefits, you will send your request to the Office of Appeals, State Department of Human Services. Remember, there are time limits within which you can appeal, so please pay attention to the notice at the bottom of the initial agency decision. Here are some other frequently asked questions. How do I get a witness to come to the hearing? A witness can come voluntarily to the hearing. However, a subpoena protects your right to have that person testify if their testimony is relevant to your case. Contact the Office of Administrative Courts well before the hearing to get a subpoena to require the witness to appear. Blank subpoenas are also available on the Office of Administrative Courts website. You must arrange to pay fees, including mileage, and have someone else serve the subpoena at least 48 hours before the hearing, not counting weekends and holidays. If you subpoena doctors or other experts, you may have to pay for their time to testify at the hearing, as well as their time to travel to the hearing. Is it okay to bring letters instead of witnesses? In general, it is better to bring witnesses who can help present your side of the case and answer any questions raised. Usually a written statement by a witness who is not present at the hearing is not allowed. Remember, this hearing is your chance to tell the judge your side. It is important to have your witnesses present at the hearing to testify and to have all of your documents at the hearing. If I forgot something, can I bring it to the judge later? In a public benefits case, if you could not get the evidence in time for the hearing, the judge may allow you to send it later. If the judge allows you to send in a document after the hearing, you must also send it to the agency, which will have a chance to respond. The judge will tell you when you have to send this additional evidence. However, the judge may also decide not to allow you to submit any documents after the hearing is over. Remember, this hearing is your chance to present your side of the case to the judge. It is important to have all of your documents ready at the hearing. What if I can't be there for my hearing date? If you cannot attend the hearing on the date and time shown, you must contact the Office of Administrative Courts as well as the opposing side as soon as you know. You can ask the judge for a continuance, which will give you a new hearing date. You must show good cause to change a hearing date. The sooner you make the request, the more likely it will be granted. Good cause includes circumstances beyond your control, such as an illness of another household member requiring your presence, a household emergency, or the unavailability of an important witness on the day of the hearing. The need for more time to get a lawyer, or, in appropriate cases, a non-attorney advisor, or to prepare for the hearing may also be considered good cause in some cases. What if I need an interpreter or accommodations under the Americans with Disabilities Act? In a public benefits case, if you cannot understand or speak the English language, you can request the agency, usually your county department, to get someone who understands and speaks both your language and the English language to help you at the hearing. If you prefer, you may bring someone of your own choice to help translate the hearing. If you need a sign language interpreter, contact the Office of Administrative Courts either by telephone, electronic mail, or letter. Our contact information is found on our website. Additionally, if you require other accommodations, contact the Office of Administrative Courts. Make sure to follow the ADA requirements and include a notification from a treating physician with your specific disability for which you require accommodations so that we can timely process your request. We understand that your administrative hearing is important. You are undoubtedly feeling anxious about appearing before the Office of Administrative Courts. While we cannot provide legal advice, we are here to assist you as much as possible. We hope that this presentation has helped outline some of the events that you can expect at your hearing.